Hello, I'm Bill Peterson, Minnesota estate planning attorney. One of the most important estate planning documents is your living will. A living will directs what medical treatment and medications you should receive when you become disabled and cannot express your own wishes. Now I say when you become disabled rather than if you become disabled because every one of us will be disabled at some point in our lives. It may be the last 10 minutes of our life or the last 10 years. Also, we may become disabled for a day or a week and then recover our ability to make decisions on our own. This is why a living will is so important. In Minnesota, a living will is sometimes called a health care directive, a power of attorney for medical care, an advanced care directive, or by several other names. The focus of the living will is that the patient designates another person to make decisions for him or her when the patient is disabled. Now, not all living wills are created equal. For example, the Federal Insurance Portability and Accountability Act, which is also known as HIPAA, can significantly affect how a hospital or clinic will interpret a person's living will. It's important that your living will is in full compliance with HIPAA. Another important thing to do is to make sure that your living will is delivered to your doctor or clinic. A carefully drafted living will has no effect if it is sitting in a lawyer's office or at home in your desk when it is needed at the hospital. What is more, some people will sign a makeshift living will that they received at the clinic just prior to a medical procedure. Many people do not realize that the makeshift living will they sign at the clinic usually invalidates the carefully written living will that they wrote with their attorney beforehand. A living will can also direct what is to be done with the bodily remains of a person after his or her death. Does the person want cremation or a traditional burial? Does the person want to donate their organs to help save others' lives? Are there other ceremonial or particular things which should be done at the funeral? These kinds of questions can also be addressed through a properly drafted living will. Lastly, there are different laws concerning living wills in other states. This means that it's important to have the living will written in such a way that it will be valid in all 50 states. It should have the proper provisions so that it is valid whether you need medical treatment here in Minnesota or in a clinic in other states such as California or Florida. It is also helpful to the estate planning attorney to have access to the living will provisions in all 50 states. That way, the client can get the best possible living will to meet his or her family's needs. When it comes to a living will, one size does not fit every circumstance. All living wills are not created equal. Now, they serve a vital part in the person's estate plan and should be crafted carefully to protect you when you become disabled. It's important that these vital decisions are made when you're fully alert and aware of your choices. I'm Bill Peterson, Minnesota estate planning attorney. If you'd like to protect yourself and your family for the time when you become disabled, I can help. Call me at 952-921-5818 for a free, no-obligation consultation. Thank you, and have a good day.